Hello, and welcome to Advisory Explained. I'm your host, Kosie Kritzinger. Join me in this series, this podcast where we discuss the complex world of advisory. We dive deep into very specific topics in the world of mergers and acquisitions, due diligence, tax, fiduciary services, and so much more, where we take complex topics and we break them down into smaller, bite-sized, palatable portions for you to understand and to understand where we can assist you. Welcome back to another episode of Advisory Explained, where we take complex topics in the world of finance, law, and asset management, and we break it down into bite-sized pieces for everyone to understand. Today, I'm privileged to have a friend and a colleague, Marcus Schaefer. He's a partner at Fairbridges, a prominent law firm in Cape Town and in Johannesburg. And he is joining me today, and we are going to discuss the topic of shareholders agreements, specifically minority protection. Marcus, welcome.
Good to be here. Thank you.
Yes, we are very excited to have you. So, Marcus, I would like to open up the conversation by asking you to explain the difference between a shareholders agreement and a MOI, a Memorandum of Incorporation. High level for our listeners.
Okay. So the MOI, or Memorandum of Incorporation, is a required document in the Companies Act. Every company in South Africa has to have one. You essentially have two forms of MOIs. You can have a standard form or a custom form MOI. If you register your company with the Companies and Intellectual Property Commission, they will issue you immediately with a standard form MOI. And you can go from there. And then you have a custom form one, which is a document that you prepare. And it gives a bit more detail and it expands on those issues. Importantly, an MOI is a public document, whereas a shareholders agreement is a private agreement between the shareholders of a company. And the shareholders agreement deals with economic issues or commercial issues between the shareholders.
So, between the MOI and the shareholders agreement, how do these actually interact with one another?
Yeah. So because the MOI is a required document, every company has one, and the shareholders agreement is not a required document. And if you don't have one, you fall back on the provisions in the MOI and the Companies Act. To the extent that there's a conflict in the shareholders agreement and the Memorandum of Incorporation, the MOI takes precedence. The MOI is a very important document, but the shareholders agreement gives a lot of the meat to the relationship between shareholders from a funding perspective, from a value retention perspective, from an exiting the relationship perspective. And these are all things that are very important in order to regulate a company properly and protect value.
Fantastic. So, would you then agree with me to say an MOI or the Memorandum of Incorporation that is the governance inside the business, whereas a shareholders agreement is more our relationship management document?
Yeah, so the MOI is exactly that. It's a governance framework. It will deal with issues such as what classes of shares are available for or authorized for issue in the company. It regulates directors' conduct. And it deals with governance issues such as how to call shareholders meetings, how to call directors meetings, and what the thresholds are for making decisions at those meetings and passing those resolutions. So from a governance perspective, the MOI is an incredibly important document. The shareholders agreement then deals with, you can think of it more as a contract between the shareholders. So you have issues that might be governance issues, but they're actually a level above. It deals with the commercial reality of that company, how majority and minority shareholders will interact going forward, and importantly, any dispute resolution mechanisms, which hopefully will avoid a scenario where you have to litigate.
Okay, fantastic. In the world of shareholders, right?
Yeah.
We work in private companies, so in a lot of times we have two types of shareholders. We've got a majority shareholder and we've got a minority shareholder. Now, when we think about resolutions and voting rights, etc., when we have a majority shareholder, it seems like they could possibly control the business. Now, there's a term that's floating around, everyone likes using it, called minority protection. Can you maybe elaborate a little bit on that?
Yeah. So as you say, if you have a scenario where you have uh, an 80%, 20%, or a 70%, 30% split, it looks like the minority shareholder is quite vulnerable to the decisions that the majority shareholder makes. But in actuality, you can have a scenario where even though you have an economic minority, you can have a level of control that is more reflective of a majority position. So an example would be where you have a company that someone has started, so you have a founder, and they then invite investment at a later stage. That investor then makes quite a large capital investment. They take 80% of the shares, which entitles them then to 80% of the value on liquidation or dividend. But they don't want to run the company. So a lot of the operational responsibility still lies with the founder being the 20% minority shareholder. So yes, you have a default situation where if you don't have a shareholders agreement that sets out all of those nuances and divides and kind of balances the power dynamic, you could have a situation where the minority shareholder is unbelievably vulnerable. And I mentioned 20% and 30%. There's even an important distinction between those two, because you have voting thresholds in the Companies Act for shareholder decisions. A special resolution requires a 75% plus supermajority in order to pass a resolution. If I'm a 20% shareholder, I'm completely vulnerable to that. If I'm a 30% shareholder, I have an ability to block it. So those are the little things that you need to think about when creating minority protection. So it's a lot about voting power and control of the company, and you can change those thresholds as well. So in our scenario, where you have a 20% minority, you can increase the percentage required for a special resolution to 85%, for example, and then you create that protection. The other protection is to create or to allow each shareholder one board appointment. So where you have, let's say, a 60%, 20%, 20% shareholding, and each shareholder is entitled to appoint one person to the board. You then have three members on the board, but a board decision is made on a majority. So you could actually have a scenario where the directors representing the 40% actually have a majority on the board. And that's how you can, depending on the context of the company itself and who the investors are and what they actually want, that's how you can manage a level of control. And then finally, what's very important from a minority protection perspective is how you exit the company. And that's where, you have provisions such as your preemptive right provisions, tag-alongs, drag-alongs, forced sales, all those kind of things that you can put in place to avoid a scenario where a minority shareholder is completely, a passenger along for the ride, and the majority shareholder can basically do what they want.
That is absolutely fantastic, and we'll get to the tag-alongs and drag-alongs in a minute. So, Marcus, when we consider in the shareholders agreement, there's two main things that sort of come into play. The first one is reserved matters, and the other one is veto rights. So, can you maybe explain the difference between the two examples and how this would actually help a minority shareholder in probably a dispute or in just the operations of the business?
Yeah. So they are different. They often require a similar threshold for passing them. So a veto right is a decision that needs a level of minority consent for it to go ahead. And those issues are usually, or we like to restrict them to issues that affect the investment value of that minority shareholder. So you don't want a situation where you create a massive amount of veto rights, so that you're essentially operationally paralyzing the business. But you do want a situation where a minority shareholder can prevent a majority shareholder from making a decision that really affects their value. So it prevents the dilution of shareholding, the sale of a major asset in the business, or anything else that will genuinely affect why they made their investment in the first place. Reserve matters can be thought of as essentially shareholder approval of major decisions in the company. Because in a company, you have two levels. You have the shareholder level and the director level. And on the director level, you are operationally running the company on a day-to-day basis. So actually, you want as much as possible to be made on that level, decisions to be made on that level. But there are certain major decisions that need to be made on a shareholder level or be approved on a shareholder level as well. So, again, that's the sale of a major asset or the sale of their core business or a shift in the core business, or taking on a massive amount of debt or amending certain core issues in the company, such as the rights that are linked to the shares that the shareholders are holding, or amending the MOI, anything like that. So reserve matters offer a level of protection where the shareholders are not required to simply accept what the directors are doing. And veto rights are essentially a level of minority protection that allows them to block any decision that they think is not in their best interest or overly prejudicial towards them.
Okay, that is actually absolutely fantastic protections in both the MI and the shareholders agreement specifically for minority shareholders. And to all of our viewers out there, it is absolutely crucial that you consider, listen, do I have a shareholders agreement in place? And then is it a proper, well-functioning document? Or is there gaps? Is it weak, drafted, etc.? Or is it purely outdated? So if you have a shareholders agreement that you need some assistance on, reach out to either myself or Marcus, and we can absolutely assist you on that. We at Baker Tilly Greenwoods strive to be trusted advisors. If that is who you are looking for, please reach out to us via our website, bakertillygreenwoods.co.za. Marcus, the next thing, and you touched on it in one of your previous comments, is at exit. Both for majority shareholders and minority shareholders, obviously we do a lot of M&A transactions. And in the world where there's both small and large shareholders in place. So tell me, you mentioned two specific key areas in the shareholders agreement called tag-alongs and drag-alongs. Can you explain the difference? I know a lot of people ask me always to explain it as well, so I'd love for you to explain to the viewers.
So I think the important thing to understand about a shareholders agreement is ultimately you're deciding at the beginning of a relationship how the relationship is going to end. And it's better to do that when we're all friends at the beginning and we have a roadmap ahead to say that in these instances, this is how it's going to work. And there's a lot of mechanisms to do that, and drag-alongs and tag-alongs are two of those. And they're kind of dealing with separate or opposite protections. In a tag-along scenario, you are protecting the minority shareholder. To give you an example, you could have a situation where a majority shareholder is made an offer for their shares that they want to accept. But it's only for their 80% shareholding.
So for instance, I make an offer for the 80% shareholder to buy out their shares at 200 Rand a share.
Exactly. And now you're faced with a situation where the minority shareholder could all of a sudden be in business with someone that they never intended to be in business with originally. And in order to prevent that, they can then trigger what's called a tag-along right. And that tag-along right requires that the shareholder that is purchasing the 80% shareholding also purchases their 20% shareholding. And it basically prevents a situation where a new partner comes in, and as a minority shareholder, you are then vulnerable to somebody that you never intended to be in business with, and you don't trust necessarily. Whereas the original partner, there was a level of trust, a level of due diligence that was done that you might not have in this scenario. A drag-along right is almost the opposite, where there's a good transaction on the table for 100% of the shares of the company. Somebody wants to come in and just take over. They make the offer, the 80% shareholder accepts the offer, but the 20% shareholder, for whatever reason, is dragging their feet or preventing the transaction from continuing. A drag-along right requires the minority shareholder to get on board and essentially sell their shares for the same value on the same terms that the majority shareholders are selling their shares for. And that's to prevent a scenario where a purchaser comes in makes an acquisition, but then they have this residual minority shareholder there that, and that's a problem for, governance reasons, or from a value extraction perspective, or simply if you just want to be in complete control. And I think the important thing is to have these protections is one thing, but they actually need to be quite well drafted, because there is a risk where, you have a tag along or drag along, right, where people are brought along that don't necessarily want to be part of the transaction. And so you need mechanisms in place to create proper and good value for everybody involved, and not to feel like one of the parties is being coerced into a deal that they never wanted to be part of.
Absolutely. We see that quite often in transactions where clients are making an offer, but they don't necessarily want everyone part of the transaction. We are busy with a gold mine transaction actually right now, and we're sitting with a bunch of significant minorities. A significant amount of very small minorities. They don't have a significant minority like above a minimum requirement to block a special resolution vote, but there's a bunch of 1 and 2% shareholders which are killing the transaction at the moment. And unfortunately, these guys don't have a shareholders agreement with tag-alongs and drag-alongs in, and it's costing them at the moment, which is actually highly uncomfortable.
So now you need to decide whether you keep those guys in,
Mm,
or whether you make them such a good offer that they are actually happy to walk away.
yeah,
Um, and if you had had a scenario where everybody would have agreed at inception that, in a scenario where we have a very good purchaser that comes in and wants to take over, that then this is the formula that we're going to use to ensure that, we get our value from it, and we don't feel like we're being bullied or coerced into joining a transaction when we actually want to retain our shareholding. And you'll find when you discuss these matters at the beginning that everybody can actually find a good level of consensus on these issues. But when you're at the end of the matter, everything becomes much more, people want to get an edge, or just make a little bit more money, and they understand the power of that they're or the leverage that they're holding over the transaction, and you want to avoid those situations if you can.
absolutely. And what we've seen is when we do shareholders agreements, it's imperative to do it when everyone is still happy and wants to be in this. It's like, and unfortunately, it's like discussing the divorce before you get married. Um, how are we going to handle it? How are we going to exit? How are we going to split the assets? What are we going to do with the kids? Um, as part of this deal at the end of the day. So it is unfortunate, but it saves you so much time and money if you do it at the beginning.
Yeah, and an unbelievable amount of grief. I mean, you know, as you mentioned, at the beginning of a transaction, everybody's at their most optimistic. And that's when you want to get on the same page. Have your rules of engagement in place, and then everybody knows how everything is going to work going forward. And that just makes things much easier.
Absolutely. And I am a firm believer in when you start a business, especially if there's more than one shareholder. Obviously, if you're a single shareholder in yourself, no big reason to have a shareholders agreement with yourself. But if you have more than one shareholder, even if you're family, even if you are best friends, that the fee you pay to get a quality MOI and a quality shareholders agreement it's an investment into your business. It's not an expense. It's not just to get something over the line. It's really it adds significant value to you as a business.
And what it also does is, if you negotiate a shareholders agreement call it at inception, and there are those issues, you realize very quickly where the issues could be going forward. And you realize that if you hadn't sat down at this point in time and actually worked through those issues, that those would have become legal disputes down the line. But now we've got a mechanism in place that everybody is kind of happy with, and is able to move forward on that basis. But to do that at the beginning is just easier for everybody. And to pay a lawyer to prepare a shareholders agreement is much better than paying a lawyer much more money to litigate on a shareholders agreement. Litigate
Absolutely.
without a shareholders agreement.
Yeah. As I've said multiple times on this podcast, I'm a chartered accountant. I'm not necessarily a content creator. So your feedback means a lot. We are actually also finalizing a different transaction at the moment in the sports travel world. and we are representing the buyers, and they are taking up a majority stake in this business. And one of the big requests from the remaining minorities was we need a very strong, significant shareholders agreement. And that came from their side, not even from the majority shareholder side. It said, listen, this needs to be part of this before we sign anything. So it's always nice to always work with clients that understand the benefit of why we are doing it and doesn't see it as just a compliance exercise.
They've probably been in business for a while and maybe got burnt a couple of times.
Probably. Tell me, Marcus, unfortunately, it does happen that there are people out there with insufficient and weak shareholders agreements. What can they do? What protection is there for them, either in common law or in Companies Act or in their MLIs? What protections do they have?
So let's work off a scenario where you don't have any shareholders agreement in place. There are protections for minority shareholders in the Companies Act. If you are subject to overly oppressive or prejudicial conduct towards you that unfairly limits your rights, you can approach a court. And then the court actually has quite a wide range of powers. If it's to do with the transaction, they could require a buyout. They could overturn the transaction. They can step in almost on a governance or regulatory level to remedy the issue. So there is a level of protection, but I would call that a safety net protection. By the time you've gotten there, there's so much has gone wrong already. The relationship is probably irretrievably broken down. There's a high risk of losing value in the business at that point in time because nobody's on the same page anymore. People are distracted. Everybody's dealing with the shareholder dispute and not dealing with actually operating the business and creating value. So it's a good thing. There are protections in place, but it's a very reactive protection. And this is why I think there is so much value in the shareholders agreement, because a big part of it is your dispute resolution mechanisms. And to ensure that where possible, there is a form of mediation or a form of internal remedy that can be used in order to prevent small issues that can actually be sorted out between people from becoming big legal disputes. And, whilst you can approach a court, there's never ever any certainty when you approach a court. Often courts are fairly reluctant to step into a private arrangement in a private company or a private agreement between shareholders. So unless there's, grossly unfair or prejudicial conduct, they like to kind of hold back a bit. So you're not guaranteed of your remedy in any event. And litigation is expensive and time consuming. You're not in business to litigate, you're in business to create value and to run your operation, and to have a shareholders agreement in place that allows you to resolve so many of those issues prior to actually going to a lawyer for litigation purposes is a massive benefit.
Absolutely. And I think there's a second half to a weak shareholders agreement is an incorrect shareholders agreement. So what happens if your shareholders agreement is actually in contrast to the MOI?
So in that case, the MOI takes precedence always, and the Companies Act for that matter as well. So where your shareholders agreement deals with issues that either are unlawful or contradict the MOI or the Companies Act, those provisions will essentially fall away and the fallback position in the MOI will apply.
Okay, fantastic. One thing that I also really just want the viewers to understand is the Companies Act sets out a lot of almost default rules in a lot of instances. So it needs to be very specifically understood what those default rules are and what the limitations on them are. There can be a world where you can change those default rules. One of the basic ones that we often do is change the level of a ordinary resolution and a special resolution. But there is a limit. So I can make my ordinary resolutions 10% if I wanted to, probably. It was a poor decision to do it. Let's call it 60%. And I can drop my special resolution to a 70%, which is still fine. However, there has to be a minimum 10% bridge between the two. So those are default rules that can be adjusted with limits in place. And it's very important to understand those, specifically in terms of directors' rules, directors' conducts, etc. Understanding all the default rules. And that's where the value of someone like a Marcus and ourselves come in, where we understand the playing area, what you're allowed to do, what you can't do, and the benefits of it, and also the risks
Yeah.
if you start playing with those default rules. And then if you change those default rules from the MOI or the Companies Act rules that govern your MOI, it's absolutely imperative to have the mechanism in your shareholders agreement on how we manage that default rule that's been adjusted.
Yeah. And you have a lot of scenarios where people want to start a business and they want to get going pretty quickly.
Mm.
So you register a company with the CIPC and it's like 5 minutes. And you're left with your custom form or your standard form MOI, which, as you mentioned, is a completely default document. And not only does it not take advantage of the adjustments that you are actually entitled to make in law, it often just leaves things vague or leaves gaps. And that's where a custom MOI or a shareholders agreement can just fill in those gaps as well. So it's not necessarily always about adjusting the default scenario, but also just adding a layer on top of it that adds context or is more appropriate for your specific scenario in your business.
Absolutely. So, and I also encourage every single one out there that's viewing this, go have a look at your actual MOI on CIPC, the Company's Intellectual Property Commission. Have a look on what is your MOI, what's the rules that's currently there in place, and consider it in terms of the Companies Act rules. Um, is yours compliant? Does it meet all the requirements? I'm not gonna show out a very specific issue that I have with a standard form, but I'm of the opinion that it does not actually meet the requirements of the Companies Act, the standard MOI that the CIPC actually issues. So, but that's a personal opinion and my interpretation of the Companies Act. So, um, reach out to us if you have more questions. Marcus, while we wrap up, from your perspective and out of your experience, can you give one piece of advice to both a majority shareholder and a minority shareholder in how they should approach a shareholders agreement?
Yeah, so for a majority shareholder, I would say don't be afraid of minority protections. I know it's called minority protections, which makes it seem like it's anti-majority, but it's actually not. What you're doing is you're setting up a clear and you know proper roadmap for how you're going to operate your business. It's essentially a rules of engagement where everybody's on board. You significantly limit the risks of losing value in the business. You significantly limit the risks of disputes, which always affect a business. And all of those things are, avoiding those things is just simply good for business. So you create a scenario where you retain your value, and you have an operation that you can, put to new investors and show that you're running a good shop and it's a good product that they'll be investing into. And all of those things are very, very important, I think, from a majority shareholder perspective. And you don't want a scenario where you feel like, or your minority partner feels like they're being bullied, or you hold an undue amount of power over them, and then you're in business with somebody that you don't get along with anymore, or is just simply unhappy with how you conduct yourself. Again, that's not very good. So I would say, from a majority shareholder perspective, don't be afraid to enter into these arrangements. They're good for everybody. From a minority shareholder perspective, I would say you have a certain amount of leverage at the negotiation stage to ensure that you protect yourself from a control and decision-making perspective, and also from a value uh, retention and an exit mechanism perspective. So ensure that at the beginning, you are absolutely clear on how you want to exit this business, in what circumstances you want to maybe join a deal or refrain from joining a deal, and make sure that you have absolute clarity on that situation. Because once you've invested and you're involved in the business as a minority shareholder and you don't have these protections in place, there is a scenario where you are simply along for the ride, and it's very difficult at that point um, to protect yourself or to negotiate a better situation for yourself. I had a client recently where it was a very simple situation, but they had a shareholding in a company that was 50%, 25%, 25%. And the 50% shareholder bought out one of the 25. So it was left with 75%. And then my client was the 25% shareholder. And this company had been going on for a really long time, and they never had a shareholders agreement in place. And and he comes to me and he says that the majority shareholders made an offer for his shares, but at a value that he thinks is significantly kind of undervalued. And he didn't want to accept the offer. He'd rather stay in the business and ensure that he's protected for his exit at some point further down the line, or at least that he can't be, that he's not going to be a victim of an oppressive majority shareholder. Um, and you know, and at that point, you have to tell your client quite a difficult truth: is that your negotiation power at this point is very difficult because the majority shareholder already wanted to buy you out. Now you want to negotiate a position where not only is it more difficult for them to do so, but it's likely more expensive for them to do so as well. And in that scenario, there's very little incentive for the majority shareholder to come to the table on that. So your leverage, your ability to negotiate is mostly at the beginning. So ensure that you are doing it then.
Absolutely. Marcus, thank you so much for all of your wisdom and your insight. And I hope that everyone that viewed today's episode got some quality information and that they will go back and think about their own MRIs, their own shareholders agreements. How are their minority protections in place? What are the reserved matters in their shareholders agreements and the veto rights? Giving them the understanding and the ability to ask the questions. Um, there's a principle called what is my circle of confidence, and my circle of confidence is what do I know, and what are the questions that I know what to ask of myself and the areas. And I hope that today will give you some more information to give you some more confidence in looking at your MI, looking at your shareholders agreement, and asking, is this still sufficient for where we are at the moment? And that is a wrap. So thank you very much for tuning into Advisory Explained, where we discussed minority protection specifically and shareholders agreements. Thank you very much.